I'm being sued for $2 million by a YouTuber, and I am so excited to get to talk about it today. It's something I've been bottling up and haven't shared with everyone for a while. And I'm joined by a special guest, Alex Shepard of Randazza Legal Group. Welcome.
Hello, hello.
All right, I'm being sued by Wealthy Inc. and Dale Buskowski. Wealthy Inc. is the owner of the trademark Derek Moneyberg. Were you aware of Derek Moneyberg before this case?
I had not heard of him. At the same time, I'm not the sort of person who goes to YouTube for a bunch of financial advice, so I'm not really the target audience.
Yeah. Have you had fun litigating against Mr. Moneyberg?
It's been interesting. I mean, this is, we're going to discuss it later, but an anti-SLAPP case.
Yeah.
And anti-SLAPP cases are always fun.
First claim is the Lanham Act. A lot of people assumed it was just defamation, but there's actually a Lanham Act. And so what's a quick breakdown of what the Lanham Act is in one or two sentences?
The Lanham Act is the federal trademark statute. That's slightly confusing here because there's no trademark violation claim or infringement claim. Rather, it's an unfair competition claim, which the Lanham Act also covers.
Yeah, so from paragraph 114 of the complaint, defendant's social media channels purport to be an independent review that provides viewers with an objective resource, speaking about me, but actually are conduits for the promotion of products, programs, and plans with which defendants are affiliated and or from which they receive compensation. It seems like with the Lanham Act, his concern was that I was selling something in competition, which is basically unfair competition. Is that fair to quick summary?
That's pretty much it. And those allegations also have to do with the fact that any claim that's under the Lanham Act has to be based on commercial speech, not just criticizing someone, but actually talking about their products and services.
Second claim is the wonderful defamation. So what actually is defamation?
So defamation isn't just saying bad things about someone, though a lot of plaintiffs would like to think that. Defamation very generally has four elements. You have to make a false statement. It has to be defamatory in nature, meaning you can't just say, falsely say that Spencer here is wearing a red shirt. That's not true, but it's not defamatory. No one thinks any less of you for it. Then it has to be of and concerning a specific person. You need to name them or identify them in some way. And then they need to have suffered some kind of damages as a result of that. There needs to actually be harm to their reputation. And then there needs to be some degree of fault, at the very least negligence. But when we talk about public figures, you need to show what's called actual malice, which means you either need to know that the statements, subjectively know that your statements are false when you make them, or you need to publish them with reckless disregard, which just means some kind of significant subjective doubt as to whether your statements are true or false. You can't just hide your head in the sand and then say, I didn't know it was false.
I think you guys can realize real quickly why I hired the Randazza Legal Group. You guys know defamation. I swear there's not a book behind the camera that you're reading from. You literally know this stuff like a textbook. So the third claim is intentional infliction of emotional distress. And this is a very important one, Alex. Infliction of emotional distress. Do you see this in every case? Because this is ridiculous.
I don't know why so many plaintiffs do this, but they do. Almost every time there is a defamation claim, there is also an IIED claim. That's sort of the shorthand for it because it's very long. And intentional infliction of emotional distress is kind of a nonsense tort the vast majority of the times it's brought because it's based on the same thing that a defamation claim is based on, just a false statement that injured your reputation. But IIED has to be way more extreme than that. It has to be some kind of conduct that is beyond the bounds of tolerability in a civilized society, pretty much. And it has to cause actual severe emotional distress. You can't just be, kind of insulted a little bit. It needs to be the sort of thing that causes you to see a therapist and, fundamentally changes your outlook on life, causes suicidal ideation, sleep loss, weight loss.
You guys were looking for it, too. In the deposition you asked, it seems like Derek Moneyberg did not present any doctor visits, any therapist visits, and so that one seems weak to me. So in the complaint, Plaintiff Buskowski suffered severe or extreme emotional distress as a proximate consequence of the acts and statements of defendants alleged previously. Severe or extreme emotional distress. How would someone prove that? It sounds like therapy, years of therapy, and something so extreme, basically.
Yeah. That's pretty much it. That's the normal evidence that you would have. You'd show, you'd have some kind of declaration maybe saying, after these statements and because of these statements, I had this I started having panic attacks and sleep loss. And then to actually prove what sort of damages you suffered, to put a dollar figure on it, you need to show that you visited a therapist, you had to go through these kinds of bills, they predicted that you would have this loss of productivity for the rest of your life, etc.
Yeah, okay, so I'm sure that comes up occasionally, but this one seemed pretty weak. But the fourth claim, the last one, is business disparagement. As the proximate result of defendant's publication of the statements set out above, plaintiffs suffered pecuniary loss and also suffered a general decline in their business and income. What is pecuniary loss?
Pecuniary just means that there is some kind of like actual dollar figure that you can attach to it. In this case, it would be, loss of revenues, loss of any kind of, a business opportunity that had a particular dollar value that was placed on it. In this case, business disparagement is really just the same thing as defamation, but at least in Nevada, which is where this case was brought, you need to distinguish between defamation and business disparagement by talking about the different kinds of damages. Because defamation can just allow you to recover for a loss of reputation and kind of hurt feelings. Business disparagement needs to be like actually about your business practices specifically and needs to harm some kind of specific business interest. It's not just general damages like a defamation claim. Interesting.
All right, I'm going to run through the damages because it seems like every case you have to have damages, and this is what he's claiming. Here's the damages he incurred. So he wants $2 million. The amount that I was unjustly enriched because he believes there was commercial speech. The plaintiffs be awarded exemplary or punitive damages against defendants, an amount approximate to punish defendants, and to make an example of defendants to the community, which I thought was real interesting. I've never heard that before, like to the community. Is that basically setting a standard? Like, this behavior is untolerated.
Yeah, that has to do with the IIED claim a bit, that you have to show that your conduct is beyond the bounds of what's socially acceptable. So that's where that comes in. Just because you say it in a complaint doesn't make it true.
I've learned that to be the case. Number 4, that plaintiffs be awarded an amount sufficient to reimburse plaintiffs for the cost of corrective advertising, that plaintiffs be awarded pre-judgment interest and attorney's fees. I imagine all these are pretty common. Nothing shocked you.
That's fairly common. Corrective advertising in particular shows up in a lot of Lanham Act cases to show that, we had to spend this much money to prove that our products aren't actually garbage that kills people.
Right. And then an important question is, how exactly does a plaintiff prove damages in a defamation case, such as this one?
So there are two ways of doing this. First, you have a specific category of statements that are called defamatory per se. And what these are kind of differs from state to state. But generally, if you falsely accuse someone of a crime or something that is completely incompatible like with their business, then that's considered defamatory per se. And at least for purposes of establishing liability, but not the amount of damages, you don't need to show anything further. You can just presume that damages exist. But for anything else, you would probably need to go through the effort of hiring an expert witness to say, based on all kinds of social media stuff, this person has harmed your reputation, which has caused this kinds of business loss, and et cetera, et cetera. It depends on what kind of case and what kind of statements you're talking about.
Important part, attorney's fees. I've spent $282,598.04, and it has been just a few weeks shy of 2 years that we've been in litigation. So I am putting a link in the description below for a GoFundMe. This has been an incredibly challenging time in my life. I'm very privileged to be able to have earned enough to be able to pay that. However, I'm stuck, and there's a chance, we'll get into in a minute, there's a chance that this is not over. I mean, we're still litigating. And so it would be more than helpful if anyone wants to help out, it'd be much appreciated. Why in the world does litigation cost so much?
Litigation's expensive. That's really all there is to it. Also, we're a very prominent First Amendment firm. We are not cheap.
I have to add in, though, there's no regrets about hiring the Randazza Legal Group. Like, these guys are incredible. I would refer a YouTuber who's struggling, like you guys do consulting too. Like, you don't have to hire them as the complete defense, but you guys do consulting, I believe. Yes?
Yeah, we can provide some advice.
Yeah, so like anything defamation, absolutely. And it's just insane how much it's cost. And I know this is like a conflict of interest because this is how you get paid, and I'm over here complaining, but I don't have a problem with lawyers. I've made a lot of jokes about lawyers in my recent videos because of how insane the cost is. I don't have a problem with the lawyers. I have a problem with the system. To me, this is so insanely bloated that I don't understand how a system could exist where a 15-minute YouTube video that, in our opinion, did not include any defamation. I did not even make the claims. We'll get to that in a minute. $282,000. Like, half of America right now can't afford a $500 unfortunate expense. There's plenty of studies. It's like 30 to 50% can't afford a $500 unfortunate expense. And then I don't know how do you litigate if you don't have the money? Like, what would happen if I couldn't afford the $282,000?
You'd have to hope that there is an attorney who's can take your defense on contingency. For the most part.
That's basically it, right? Because with criminal, you do have the ability to get a public attorney with criminal cases, but civil, you do not. That's something I learned. Now, granted, I hired the best. So if I would have bargain shopped, arguably I could have saved costs there. But I think, and I'll give you a chance to defend yourself, the benefit of hiring the best is the happy path still exists where I get my money back, which we'll discuss at the end. But maybe 1 or 2 cents why hiring someone who really knows defamation law, why that could be a benefit, even just ignore the costs.
Well, at the end of the day, this case is either going to get dismissed before trial or it's going to go to trial. And trial, in every case, is an extremely expensive endeavor. That's why the vast majority of civil cases are going to settle or get disposed of before trial takes place. And when you hire a law firm that specializes in the First Amendment, we know what we're doing, there's a much higher chance that you actually get the case dismissed before trial happens.
What we're hoping for. That's what I'm talking it into existence. All right, so real quick background for everyone on the videos. The first video was released in December of 2020. It's middle of May 2023. So this is a video that I made 2.5 years ago. So basically, there was a guy named Derek Moneyberg. He was popping off on social media. A few people in the comments said, hey, go check this guy out. At this time, I was doing a series called Authentic or Charlatan, and I just wanted to do an objective review of this guy, Derek Moneyberg. I had a couple friends out here in Vegas that knew of this guy, John Anthony Lifestyle on YouTube, real name John Mulvihill, and I reached out to John because he had made 6 to 10 videos on this guy named Derek Moneyberg. He clearly had a personal experience with him. I felt like he knew him better than anyone else. And so I didn't want to make a video just speculating on anything about Derek Moneyberg. I figured it would be best to interview someone who knew him, had a possible business relationship in the past or working relationship. And so I reached out to John and I essentially interviewed him. We created 2 videos. The first one that was released was a video that a source essentially who worked for Derek Moneyberg's courses, created the courses. He spoke and helped us make the video. So I interviewed John Mulvihill for the first video. We released it December 2020. The second video was released February 2021. So those are essentially the 2 videos in question. For those of you who were watching, you probably didn't follow me back then because it was so long ago. It was so ridiculous. All right, so let's get to the claims. This is really the meat of the lawsuit. I never said anything defamatory. Do you remember me ever saying any words that were defamatory in the even words that could be misconstrued as defamatory? I never did.
Well, our position is that no one said anything defamatory.
Right. I never said anything. I interviewed someone, a credible source, and I got sued for defamation. That to me is very scary. And that's why I want to start a GoFundMe to hopefully not only fund me, but fund other creators, because this, in my opinion, is the epitome of a SLAPP lawsuit. You had videos that were not positive about someone. They believe they were defamatory, and they can leverage the legal system to essentially silence someone. And I think this is a very dangerous case if we allow bullies, I'll call them bullies, not referring to Derek Moneyberg as a bully, don't sweat over there. I'm referring to anyone who would abuse the legal system to essentially silence criticism. It is very easy to wipe out a lot of creators because not many are fortunate enough to have earned the amount I have to be able to support themselves. And so I just think it's a very dangerous precedent to allow this. And so I hope the judge rules in our favor for many different reasons, one of which is to shut down this behavior and not allow it to go to court and ruin someone's life. Rant over. So this is from our opposition to plaintiff's MSJ, which would be motion for summary judgment. Cornelia had already heard many of Mulvihill's claims stated in the first and second video in videos that Mulvihill had published previously, and the fact they were still available on YouTube and there had been no legal action taken against them made Mulvihill appear more credible to Cornelia. This to me is a really important fact of this case, the fact that John Mulvihill had multiple videos on his channel for months, I think more than 6 months, with no legal action. I know you have to watch your words carefully because some of this might be attorney's eyes only or confidential, but why would I get sued? Are you allowed to answer?
Well, as far as why they sued you before suing Mulvihill, I have no idea.
I still have no idea.
Yeah, we asked that question to both Moneyberg's attorneys and to himself during his depositions. and didn't provide an answer. So that is still a mystery to us.
I thought he answered in a different deposition. It was attorney's eyes only. So, like, you guys knew and you weren't allowed to share with me. Okay. So the first alleged defamatory claim is that Mr. Buzkowski didn't graduate college from the University of Chicago Booth School of Business. Mulvihill, the guy I interviewed, alleged that Dale might have been going to an online school of some sort. This, to me, the idea of defamation on someone believing you might not have gone to school. I don't know if you have anything to add. I just felt that was a very weak claim. Yeah, very irrelevant.
All I can just say is what Moneyberg's theory is, kind of catastrophizing about how if his education credentials are called into question, then that means, there's just this situation in which everyone thinks that everything he has said about his life and his source of authority as to advising people on financial matters just collapses like a house of cards. So, I mean, whether that's actually credible, that's for the judge to decide, but that's more or less their position.
The second alleged defamatory claim is that, and by the way, this is all but from Mulvihill, is that Mr. Buzkowski's company, Larson Consulting, could be a front for money laundering. Basically what John said is it looks very well like it could be a front for laundering money. What I found really interesting about this is that Larson Consulting's address is a residential home that Dale doesn't even live in, which is just funny. I'm just stating, you don't have to add color commentary because I know we need to watch what we say. The third alleged defamatory claim is that Mr. Buzkowski engaged in illicit drug manufacturing and or sale. There's basically an asset forfeiture, seizure case for a house that he had credit cards and mail at, and it ended up being seized for drug manufacturing. And we've asked questions in deposition. I'll leave it at that. Fair? Anything to add?
No, that's fine. Just a civil asset forfeiture
case.
Civil
civil asset forfeiture. Dale's father and uncle were allegedly operating a marijuana grow operation. There might have been, I think there was some legal, they went to jail. I think he disclosed that in his deposition. They went to jail for drug. Yes?
I think there was I think Dale's father had some time ago gone to jail for some drug violations, and then his friend, who was also allegedly involved in this, and old college roommate, I think, was arrested in connection with it.
Right. And in the arrest, Dale's, I believe it was mail and credit cards were found at the property that was called into question. And we'll just leave it at that. But I felt like a reasonable person. Hearing Mr. Mulvihill stated those things, I didn't think it was unreasonable to think that he was lying. So the fourth claim is Mulvihill alleges that Buzkowski could have been involved in some capacity in his arrest in 2013. This is a really challenging thing. You mentioned it in the filings. He was speaking about a personal experience, and I simply asked questions like, how is that a claim against me?
Right. I mean, you can analogize this to a reporter interviewing someone.
Right. Tell me about your experience, and then you share it, and then I get sued for defamation. Right. Like, how in the world does that happen?
Yeah. I mean, the theory is just that by publishing the video, you become liable for all of these statements. We've contested that, but that's a whole legal issue.
Yep. The fifth and final claim is essentially Mulvihill claiming that Buzkowski's business engaged in business misconduct by helping their clients obtain credit to pay for the courses and not creating the actual material in the courses. So we had a source who alleged that, they had awareness of someone creating Dale Buzkowski's courses for him. He is a guru who sells expensive products. I don't know the efficacy of the products. I don't know if they're good or not. I'm not speaking about that. I've never gone through them. However, someone has come to us that they were the ones that created the courses, essentially. And so we shared that in a video. And even in his deposition, he shared that he doesn't fully create it, to my knowledge, right? Wasn't that? Do you remember specifically?
Yes, I think we can say publicly, he hires
a marketing agency, and they helped. Yeah, we just know that they helped.
It's a whole system of independent contractors.
Yeah, cool. I never made any of these claims. Let's make this very clear. I asked questions. This was a video. I didn't come out with a video just speculating on some guy I don't know. I asked questions as a reporter. I still am just. It's been really hard on me for 2 years. If I would have done anything wrong, I would take it on the chin. But when you just ask questions like a reporter, I'm a YouTuber asking questions about someone, and then I get sued for defamation in a life-altering 2 years. It's tough, man.
Yeah,
it's tough.
It's tough.
So here's something I did say that we admitted to. Derek, at the time the video was released, his Instagram was taken down. We do not know why it was taken down. I speculated in the comments that Derek's man boobs were against Instagram's terms of service, leading to an immediate termination. In the email, Instagram made it clear that Derek is at least 50 pounds away from appeal court. He included that in the lawsuit. I've read that 62 times, and it's funny every single time. I know you're not trying to laugh.
The funny thing is, For listeners, that is very obviously not defamatory. It's ludicrous to say that it is. And the complaint is not even clear as to whether they're claiming it's defamatory. They just include it as an example of, oh, well, this just means that Spencer is, not a serious person. There's nothing to try to verify his statements. It's like, no.
Have you seen in the deposition?
You're just shit talking. That's it.
He talks about stepping on a scale. Did you see that in the deposition? You were there, weren't you? He shared that he's been stepping on a scale recently. Didn't he share the images too?
It was like some I forget, like body fat test or something that he had recently done. Yeah,
this is a $300,000 laugh, by the way. I have to enjoy myself after ruining my life. Oh my god, that was so funny, and it's also like 2 years later. And to his credit, it sounds like he's lost a lot of weight, which I hope he has. If he's gotten healthier, good for him. But at the time, if I showed pictures, I think many people would believe he had man boobs as well. Paragraph 110 from the complaint. Aside from losing clients as a result of the defendant's false statements alleged in this complaint, Mr. Buzkowski has endured significant mental anguish, including anxiety, tension, lost sleep, and overeating as a result of defendants and Mr. Mulvihill's false and defamatory statements. So I laughed so hard at that. He included that in the complaint. Is this something other people include? Like, you included that you were overeating.
So that actually has to do with trying to sufficiently state a claim, probably for intentional infliction of emotional distress, saying that because of these statements, you had these physical, manifestations of distress, which included overeating and gaining weight, for among other things, calling him fat, which is a little ironic.
All right, let's get more serious, Alex. More serious. This is a serious case. This is super serious. So I have a good friend named Coffeezilla. Are you familiar with that YouTuber?
Yes.
He's kind of in the similar space as I am. He has made a lot of videos highlighting, exposing is probably the right word, of bad business practices. And so I want to give you a chance to... He's probably the biggest name for someone that could possibly experience a defamation lawsuit. And so this little section, we'll kind of dive into anti-SLAPP and what exactly this is. So first question, what can someone do to avoid a lawsuit?
Don't talk.
That's the lawyers. Yeah, you guys are the worst. Like, hey, Alex, can I make this awesome video? Don't say a word. Yeah, what I found is that you can't avoid a lawsuit, right? There's no way to truly avoid. If I wanted to sue you, you could file a complaint.
Yes. People can sue anyone for anything. Now, if you sue someone over nonsense, there's a good chance it gets dismissed very quickly, and you might get your attorney's fees. But
quick question, do attorneys ever get reprimanded on the plaintiff side if they file such a ludicrous lawsuit that it gets dismissed? Is that an option too?
So there's a thing, at least in federal court, called Rule 11 that says that by signing a document like a complaint, any attorney certifies that they've done a thorough investigation of all the facts and all the legal arguments are supported and everything. And if someone files absolute nonsense, you can at least in theory try to sanction an attorney for signing a nonsense document. The problem is that in reality, Rule 11 sanctions are almost never awarded.
Got it. And then as a journalist, let's say journalist, whatever you want to call it, YouTuber, journalist, reporter, what are steps someone can do to reduce the liability as much as possible for a possible defamation case?
One thing to do in particular is to make sure that you are laying out very clearly and accessibly to your audience what facts you are basing all of your statements on. It's very much a defense to a defamation claim to lay out the facts, make sure that the underlying facts that you're talking about are correct, to the best of your ability, and then you can state your opinions based on those disclosed facts. And even if someone disagrees with your characterization of facts, so long as you lay those out, then that will, in most cases, prevent you from being liable for defamation.
Let's talk about sources too. I believe John Mulvihill is a credible source. After his deposition, I think he knocked it out of the park. I think we're very confident that he was a great source. But that's obviously a part of reporting or making videos, is you have people reach out to you, say, hey, I got scammed or I was wronged by some way. What are the steps you can take to basically vet a source or make sure that a source is qualified in the terms of court?
That's largely a journalistic matter, really, determining the credibility of a witness here. But it has to do with whether doing some kind of independent background research, looking at public documents, anything that's available online to try and back up or support what a person is saying to you. If they're making wild, outlandish claims and you just take them at face value, then yeah, that's a problem. That can be possibly an indicator of even actual malice. but really just doing your own independent research and trying to corroborate their claims with another witness, if at all possible.
Yep.
Just standard journalistic practices help a lot.
Yeah, so defamation, was there malice? That's the first question that a court will ask, correct? Was there actual malice in a defamation case?
When we're talking about a public figure plaintiff, yes. If we're talking about a private figure plaintiff, and those are very different
Okay, let's
things.
get in that real quick.
Sure.
What's the difference between public figure and private figure?
So a public figure, you can be a public figure in a couple different ways. There's a general purpose public figure, which is just like a really big name celebrity, household name. Not a lot of people qualify for it. Then you have limited purpose public figures. Those are people who don't have that kind of name recognition, but within the context of a particular discussion or dispute, they have a lot of prominence. And it can be just in relation to kind of a limited community, maybe like a certain online forum or something that has a couple thousand members. Maybe there's one person that's especially popular there. And that person might be a limited purpose public figure when you're talking about something that he said or did within the context of that forum.
Yeah, and with limited purpose, if you're running ads, you're putting yourself into the public spotlight. That seems to be part of the definition. Like if you're voicing your opinion in a public forum, that seems to be an important piece of limited purpose public figure.
Yes, that by itself isn't sufficient, but when you're actually trying to seek attention on this particular topic, and you've actually done so, people are paying attention to you, they're reporting on you, then yeah, that's one of the hallmarks of limited purpose public figure
And
status.
private figure is essentially your neighbor. They're not out there. No one knows them. And the difference here is that there is a different burden of what's the importance of the two, of trying to prove someone's a limited purpose public figure versus private figure?
Yeah, this has to do with the defamation claim. If you are a public figure, whether general purpose or limited purpose, then you have to show that the defendant published their statements with actual malice, which I mentioned earlier was knowing falsity or reckless disregard for the truth. If you're a private figure, however, then the plaintiff only needs to show negligence.
The term SLAPP lawsuit has gotten brought up to me a lot. This idea of SLAPP. People see defamation, they immediately go, oh, you can file a SLAPP lawsuit, or is it a SLAPP case? What does SLAPP mean? SLAPP.
It's an acronym for Strategic Lawsuit Against Public Participation. And this is just a case, sort of the stereotypical SLAPP case is when you have a very wealthy person who doesn't like what someone said about them, usually online, and then files a lawsuit. Not because they actually suffered any damages or because they actually have any legitimate claim, but just because they want to shut someone up.
Does your business name have to be wealthy?
It helps.
Yeah. I've read this online. SLAPPs are effective because even a meritless lawsuit can take years and many thousands of dollars to defend. That is an understatement. Many thousands of dollars. If it would have cost me thousands of dollars, I'd have a Lamborghini paid in cash outside. And so with a SLAPP lawsuit, a lot of people think you just file an anti-SLAPP and then it's over. What is an anti-SLAPP? What does anti-SLAPP mean?
So there are several states that have passed what are called anti-SLAPP statutes. These are laws that are meant to combat SLAPP suits and kind of stop them in their tracks before a defendant can be burdened with all of the costs of litigation, like going through the whole discovery process, which takes a long time and a lot of money. And each state's anti-SLAPP statute differs, but California and Nevada sort of have the gold standards that a lot of other states have adopted. And this is something that allows you to file an anti-SLAPP motion, which is either a special motion to dismiss or special motion to strike, depends on the state, that allows you to get rid of one of these SLAPP suits very early on, before discovery takes place. In fact, when you're in state court, at least, filing one of these motions just stops discovery outright, does not let it proceed, and the plaintiff has to put forth actual admissible evidence to show that their claims have merit. And if they can't do that, then the claim gets tossed and the defendant gets their attorney's fees.
Did you know that not all states have anti-SLAPP protection?
I'm well aware of that.
Yeah, that's scary. Antislap.org, the website, classifies California and Nevada as an A rating, to your point, and the state Coffeezilla lives in is classified as a B rating. So what would be the difference between an A rating and a B rating, or a state that doesn't have as strong anti-SLAPP protection? Do you know the difference? What would be the difference?
It depends on what state you're talking about, but sort of the hallmarks of a really strong anti-SLAPP statute are, one, something that lets you dismiss one of these claims with prejudice, meaning they can't be refiled or amended at the outset before discovery takes place. Another is something that outright stops discovery. A third really important component is the immediate right to an appeal in case the anti-SLAPP motion is denied. Because it's possible to run into a state court judge who doesn't really understand defamation law or an anti-SLAPP statute and makes a bad ruling. If you're not allowed to appeal that immediately, then you have to go through the whole process of discovery. You have to wait until trial or the case otherwise gets disposed of, and then you can try to appeal that denial. But then you're tens, maybe hundreds of thousands of dollars in fees later, and the whole purpose of the early dismissal that the anti-SLAPP statute allows is defeated.
Coffeezilla has insurance, as well as other YouTubers have this idea of insurance, media insurance. Are you familiar with media insurance, or is that generally a benefit to someone other than just helping with fees? Are you aware?
I'm not an insurance expert. I think that if you're in the business of reporting on a lot of wealthy individuals and making statements that are critical of them, yeah, if you can get some kind of media liability insurance, it likely helps. One possible complication there is that defamation is typically considered what's called an intentional tort, rather than something that so there might be issues with an insurance policy that covers intentional torts as opposed to policies that just cover negligent claims.
Yeah, I was wondering about that. If you're reckless, for instance, could you just be reckless and be like, oh, my insurance is going to cover me? Probably not. I imagine they look at the video and say, you were reckless. We can't. I don't know if that happens, but I wouldn't want to trust if you're behaving recklessly, even though you have insurance.
Yeah, I don't have much personal experience with that, but that's an issue. Some insurance policies might explicitly exclude any claims for intentional torts in their policies.
And also with insurance companies hires their attorneys. I was able to hire you guys, who I believe are one of the best, arguably the best in the state of Nevada. And so I was able to choose my attorneys. And theoretically, I mean, the happy path still exists, where our best path still happens. And if we can get that outcome, I'd argue that my path was probably better, right? I mean, under the interpretation that insurance companies could hire anyone, and that may not be your best legal defense. Fair?
Yeah, and I've worked on a few cases where we've been brought in on insurance defense cases. So it's not as though having a fairly high-profile law firm on a defamation case is an impossibility. But I think that, yes, you do have some limited control over what firm the insurance provider actually hires.
From the start, when I told people about the lawsuit, they immediately go, oh, you can countersue, right? You can countersue. A lot of people believe that you just immediately countersue. And so from a legal perspective, what is the idea of countersuing? Like, I don't think that was never even an option. Why would someone countersue? Why do people believe that countersuing is always the option?
I think that there's some confusion between countersuing and asking for your attorney's fees. Because in an anti-SLAPP case, yes, if you file an anti-SLAPP motion and win, you get your attorney's fees back. Countersuing means bringing a counterclaim, which means that you have some kind of legal claim against the person who sued you that is separate from the fact of them filing a lawsuit against you. Filing a counterclaim is just an efficient means of getting everyone's beefs resolved in one lawsuit instead of several.
Yeah, and let's make this very clear. What we really want is the anti-SLAPP motion to be granted. Is that the correct terminology?
Yes.
We filed an anti-SLAPP motion, and so if the judge views it and grants it, I will receive all of my legal fees back. So that still exists.
Mm-hmm.
So that's the difference between like countersuing and awarding legal fees, it sounds like.
Yes.
All right. A conversation that I'm really excited to have is about the idea of perjury. What is perjury, Mr. Alex?
Perjury is just making a knowingly false statement under oath. This can be in a deposition. It can be in a court proceeding. It can be in a written document that you sign under oath.
We'll start with a light one. In the complaint, Mr. Buskowski, he filed the complaint. So he wrote, Mr. Buskowski had previously served as an executive coach and member of the board of directors of Real Social Dynamics, the world's largest dating coaching company since November 2003, which, by the way, I just realized he wrote that in the complaint. In his deposition, when asked about a scandal involving Julian Blanc, who was this was a kind of a really big scandal all over CNN, he seemed to want to dance around the topic and mentioned that he began with RSD in 2014. And so we have a very clear discrepancy between beginning employment in November 2003 and then in deposition, under oath, he claimed 2014. In your opinion, is that a form of perjury? That seems to be enough of a difference that he seemed to want to avoid certain topics and during deposition.
So it certainly suggests that he made a false statement and probably made so knowingly. The problem is proving this, because you mentioned that, yes, he did say that in his complaint that he started with RSD in 2003. But the complaint is not something that he, signed under oath. That's something that his attorneys filed and signed on his behalf. So we don't have, this sworn statement that, oh yes, I started with RSD in 2003, and then later contradicted that also under oath.
We need to be very empathetic too, because Dale has poor memory. Or we think it's poor memory, a condition maybe, because anything questionable in the deposition, it seemed like he didn't remember. He can remember certain things about he remembers his entire past, but then when it was you and Mark were asking him questions, he seemed to forget a lot of important details.
It's sort of an open secret that in depositions, a lot of people will say that they have a poor recollection of facts that they don't want to testify about. I don't think it's really beyond the pale to say that, yeah, there's a good chance that's what happened to you.
Yeah, absolutely. How
about
him stating that he lives in Incline Village, Nevada in the complaint? In the deposition, he provided an address that he lived at in Incline Village, Nevada. I looked up that address, found the owner, talked to the owner on the phone. The owner claimed that Dale Buskowski does not live or rent there, has never done that. We got him under deposition saying that to be true. And yet he claimed under oath that he lived at an address that he does not live at. To me, that is blatant perjury. What is your legal opinion on that?
He has a very flexible definition of what live means.
I wish the case was over so we could be honest about this whole thing. I appreciate your professional opinion.
That's all I'll say.
Okay, understood. Mark asked him during deposition, and sorry, we haven't really introduced Mark. Mark Rendaz is the owner of the firm. He wasn't able to make it today. He asked Dale during depositions about which magazines Dale paid for and which were organic. And Dale seemed to forget. This seemed to be pretty important. It was important to the idea of a public figure, on introducing yourself into the public. And so it's just another example of, it's just frustrating. And I know you're not going to add much color commentary here, but it's very frustrating from my perspective because we've acted completely ethically. I've answered every question honestly, and yet we're in litigation with someone who I feel like dances around certain answers in deposition.
Yeah, it can be frustrating. I mean, it's really commonplace for...
So many times I could have lied. I could have just lied. I could have just been like, that didn't happen, or this didn't happen, or...
But you don't. You follow the rules because the rules are there, not because you think that you'll get caught if you don't follow the rules.
It's so frustrating. In our reply to the motion for leave to conduct additional discovery, rather than allowing his deposition to be taken in good faith, Plaintiff Buskowski treated his deposition like a game where the goal was to not remember anything, lie about everything, and truthfully answer nothing. For those people who love lawsuits, you guys nailed your motions. You guys were having fun. I could tell initially you guys were like, oh, this is kind of annoying. Then at the end, you guys added a Super Troopers reference. I actually really enjoyed reading the complaints. Reading legal documents. You made it somehow entertaining. But that's how I felt too. It's like we're sitting there. I was in the deposition with him. Mm-hmm. You're in the room.
Yeah, that's one of Mark's specialties, adding that little spice that gets people's attention.
So during Dale's deposition, he magically forgot that his girlfriend's name was on the electric bill at a property that came into question during our case. That's just another example. This was during Mulvihill's questioning when his attorneys were questioning. Just another example of, there were so many instances I just felt like he was not answering truthfully. Our belief was that he was not answering truthfully. Like there was empirical evidence contradicting what he was saying. All right, I'm going to go through another one. In our opposition to plaintiff's MSJ, given the evasive and dishonest way that Buskowski conducted himself in his depositions, it would take a deep level of charity to hypothesize that he has ever uttered a true word in his life. However, let us be charitable. That's so funny. I had to add because it was humorous.
Oh, yeah.
All right, so we ended up consolidating cases. Essentially, I was sued in one complaint, and then John Mulvihill was sued in another. We consolidated cases. And so what's one sentence, what's a consolidation mean?
Consolidation is just when you have two cases that are very similar, have similar facts and legal issues, and for the sake of convenience and efficiency, you just plop them together into one case.
Derek Moneyberg, I've been told, has seen an increase in income and revenue and social media numbers since the videos were published. Do you believe that this will be an important fact of the case? The fact that he's claiming damages, he's going, I was defamed, I have damages, but his social media numbers, income, and revenue have all increased. Do you feel that that's an important fact of the case?
It's certainly inconvenient for his theory of damages. I mean, we explained in our briefing that his expert report on damages has a lot of problems with it. Pretty much just assumes that that plaintiffs were going to lose the same number of customers as a result of these statements over the course of years with the same number every single month, which is, an implausible trend.
It was like 10 years.
Yeah.
He's like apparently still losing customers 10 years from now. I don't know if I'm able to share the number, but it was a big number of how many customers per week he'd be losing. I looked at that. I was like, how is this happening? That I have to spend significant sums of money to defend against this nonsense?
Yeah, it's a bad expert opinion, and hopefully, the court is going to realize it as such. But we don't know yet.
So.
We'll have to see.
What do we call that period, by the way? Is it the motion stage? What's the legal jargon of just the period of time?
So you essentially have a few different stages of litigation. The first is just your kind of pleadings stage. That's the complaint. That's the answer. That's trying to dismiss a case right at the outset. If the case doesn't get resolved there, then you go to discovery, which is usually the longest and most expensive part. Then you go to the dispositive motion stage, which is motions for summary judgment. And then if that doesn't resolve the case, then you go into trial and preparing for trial.
What's the reasoning for not filing a motion for summary judgment immediately?
So this is one of the real inconveniences of litigating a SLAPP case in federal court. Because I mentioned earlier that California and Nevada's anti-SLAPP statutes, they stay discovery. As soon as you file one, discovery stops, and the plaintiff has to provide their evidence. However, in federal court, that's not the case. Because there are, for reasons I won't go into because they're a little bit boring and long-winded, not all aspects of these statutes apply in federal court because some of them can conflict with the federal rules of civil procedure. And the federal rules don't create an automatic stay of discovery upon filing a motion to dismiss.
And to be clear, that's because the Lanham Act was one of these claims. So if you remove the Lanham Act, theoretically I would have decreased my costs a lot because it just would have been, we could have possibly filed a motion for summary judgment earlier and not gone through discovery?
Yeah, there wouldn't have been a basis for the federal court's subject matter jurisdiction if not for this federal claim. Because there's a thing called diversity jurisdiction where if everyone's from different states and the amount in controversy is over $75,000, you can sue in federal court. But because Buczkowski claimed that he lived in Nevada, that wouldn't have applied here. Got it.
Okay. And what's really interesting about the consolidation cases, we have another case, the Mulvihill case. John Mulvihill does not live in the state of Nevada. We found Dale Buczkowski to not live in the state of Nevada. However, that case was filed in the state of Nevada. Do you believe that there's possible jurisdiction issues for that case and it could get dismissed based on jurisdiction? There are
significant personal jurisdiction issues there, which is why all the defendants in that case filed motions to dismiss for lack of personal jurisdiction. The briefing there has a much better overview of their arguments than I have. But yeah, essentially the main theory that Buczkowski had for saying that personal jurisdiction was appropriate there is because he lives in Nevada and suffered all of his reputational injury there. But yeah, when there's significant questions as to whether he even lives in Nevada, then yeah, that kind of undermines your main jurisdictional hook there.
My hope is that the judge sees all of this and before he even looks at all of our arguments, just immediately has an opinion about Dale of just a questionable character. Is that fair to say that some of the stuff he's been doing has been questionable? Is that fair?
So I think that, yes, if you take a look at all of the conduct, everything that we've cited in our briefing, yeah, there's a good chance that the court maybe thinks his credibility could be called into question. That's unfortunately not especially relevant when we're talking about these motions for summary judgment and these anti-SLAPP motions, because a court is not allowed to weigh the credibility of witnesses or the evidence. Just has to say, do you have evidence on these issues? Is it admissible? Is there a genuine dispute of a fact that has some bearing on these legal questions? And if there is, then summary judgment gets denied. So just because Buczkowski is maybe a little bit untrustworthy in some of his testimony, or it's a bit questionable, that doesn't necessarily resolve things at this stage.
Yeah, but it could cloud his mind, right? I'm holding out hope. Come on, Alex, I'm holding out hope that Mahan's going to look at this and come to the right decision.
Judges are supposed to be neutral arbiters, but judges
I only want them on my side.
But judges are also people.
Yeah, totally get it. So where are we currently at in the process right now? My case.
Right now, summary judgment has been briefed. It's been briefed for everyone, both in your case and in the consolidated Mulvihill case. So right now, it's just a matter of waiting for the judge to issue a decision.
And we believe that it could be up to 6 months, possibly longer?
judges have their own timeline. There are some internal rules and policies about when a judge is supposed to rule on a motion, but it's ultimately just kind of left to their discretion. So yeah, matter of months.
So I'm going to talk this into existence. In 6 months from now, I'm going to wake up one morning. You and Mark are going to call me. You're not going to email me. You're going to call me and say, the motion to dismiss was granted. We won. So I'm talking this into existence. All right? Can you envision this? It's going to happen.
All right.
And this is how it's going to play out. Yes.
I'm imagining it. Yes.
So you're going to call me with, and the motion to dismiss is granted. That means the case is over. Yes?
Well, it can.
Okay.
The thing is, if this anti-SLAPP motion gets granted, in all respects, it dismisses all of plaintiff's claims, then yes, you win. Then we can start talking about getting attorney's fees. However, that doesn't necessarily end things, because you can always appeal. You can try to go to, in this case, it would be the Ninth Circuit Court of Appeals, and the plaintiffs could say, well, the district court got it wrong. They actually should have denied the anti-SLAPP motion. And, we might have to go through that process.
Which is why I need a GoFundMe, because, yeah, it's still not over. Like, there's still more expense. I'm anticipating more expenses. I think he's going to fight it. I fully believe that it's going to get dismissed. I think the judge is going to see this for what it is. He'll dismiss it, award the anti-SLAPP motion, and we'll continue fighting. From our opposition to the plaintiff's MSJ, this was an email we received before releasing the videos, we being me and Mulvihill. The source mentioning that he received no valuable information because he didn't purchase the most expensive ticket, and that Buzkowski tried to seduce the girlfriend of an attendee during one of Buzkowski's conferences. I had to add that in. It was so funny. Like John Mulvihill received so many funny is not the right word, because it was unfortunately people who felt that they were victims of Buzkowski's courses.
Funny in retrospect.
Yeah, funny in retrospect for us, but not for, obviously, the people who felt wronged. But Buzkowski tried to seduce the girlfriend of an attendee during one of his conferences.
There's a lot of stories about this guy.
Yeah, oh man. Sometimes litigation could be fun, right? So sometimes. I did forget to mention that in the video, in one of the videos I mentioned at the beginning that we received information from a source, and I just said, all of these are just allegations from a source. Please do your own research. How much power does that have in a court?
It helps. It's not dispositive all on its own, but it helps prime your audience realize that you're not making, definitive statements about something, that there's still, perhaps a little bit of uncertainty, that they need to do their own fact-checking and form their own opinions. That helps in showing a judge that that your audience is not necessarily going to take you at face value, that this is an established fact. That helps in providing a defense against the defamation claim. That by itself doesn't solve the problem, but it's a relevant fact.
There was a plethora of people on crypto Twitter that during the crypto bull run, they're always saying, this is not financial advice, but this coin's going to 100x. And they think that this is like, and the whole time, even before this case, when I understand law a little better, I realized how ridiculous that was to say this. And they think it's like some stop all, like, oh, I can't get in trouble for doing this.
Yeah.
It was so annoying that everyone in crypto Twitter, and this branched out into other areas of anything investing related, was like, this isn't financial advice. It got so annoying because the people saying this that it's almost irrelevant.
Yeah, there are no magic words that just prevent any kind of liability.
Oh, thank God you said this isn't financial advice, but you saying the Pepe meme coin's going to 5x.
Yeah, like the classic example of this in defamation cases is, you can't just make a defamatory factual statement about someone and then preface it by saying, well, in my opinion. You can't just say, in my opinion, Spencer, murdered his girlfriend.
Yeah. Oh, thank God you said that. Woo! So another funny sentence that you guys wrote into the plaintiff's MSJ, or the opposition to the plaintiff's MSJ, Cornelia felt it was reasonable and accurate to call Buzkowski a scammer and a charlatan. In fact, such terms used seem downright kind when one reviews the evidence.
I mean, you've dealt with a bunch of people in this sphere. I trust your judgment on that.
In regards to settlements, we haven't resolved the matter, since I know people ask. Mm-hmm. See, I was going to have a really fun segment, but Alex shut me down like all lawyers do. Shut up!
Don't talk about settlement discussions.
Dale's deposition behavior is another topic. So we were sitting in, anyone's never been in a deposition, you essentially go to a small room. It's a few lawyers. There is someone, what do you call them, where they take notes?
A court reporter.
Court reporter, and it's the person being deposed. And so I actually went here in Vegas, and Dale Buzkowski was there. About 5 minutes in, mind you, Dale Buzkowski filed the complaint. So he filed the document. Mulvihill's attorneys began asking him, can you please go to page 3, paragraph 15, you know exactly what I'm getting at. In paragraph 15, I'm going to ask you a couple questions. Can you please read? Sounds like that's a common courtesy that lawyers ask. And so he says, yes, give me a moment. And then he read the entire complaint that he filed. Alex and I were sitting in a room for like 38 minutes.
That sounds about right.
It was 38 to 43 minutes, I think. Everyone was sitting there looking at each other. Even his attorney's like, come on, speed your client up here. He read the complaint he filed. Is that the first time you've ever seen that?
I think that, well, that's not the first time. It had happened previously in this case.
Of course. Yeah, of course. No, I meant for any other person you're suing.
It's a pretty unusual tactic. I don't know what the purpose of it is. It doesn't actually impede a deposition because you're doing this off the clock. You have so many hours of deposition time, but you can take breaks. And when you're asking someone to read a document like that, or they ask to read it, then they're doing it off the clock.
Well, what's so frustrating to me is I feel like this case has been elongated the most possible. Like if going in, when I first called you guys, said, hey, I'm getting sued. If you had to map out the longest timeline, this would be it. Right? I mean, 10 months, it was like 10 or 12 months where I was sued. We went through all this legal matter, and then Mulvihill gets sued. So then it extends. I remember in August of last year, it was on my birthday, literally on my birthday. I was in a good mood until you guys called me. You guys always have the worst phone. Whenever Mark calls me, I'm like, oh, no. Oh, no. I'm traumatized, seriously. Like, whenever you guys call me, it's always bad news because it's always expensive. I just felt like the timeline was so elongated. Was it the longest possible timeline?
Unless we were talking about, possibly some appeals of minor issues. Like maybe if, say, Buczkowski had filed, like, a motion for a preliminary injunction against you or something like that to, force you to bring down your videos, and then that got denied, and then you could have tried to appeal that denial, and that would have taken some time. That's probably the only, like, semi-realistic trajectory that would take longer.
Yeah, it just felt like this whole case, everything that came up. There was an example is that hearing we had one day where we were asking for dates for a second deposition for Dale, and it just felt like he was kind of dancing around it. He was tough during the first deposition. He wouldn't answer questions, so it forced us to do a second. We had a hearing. We had to go to court. Mm-hmm. That cost me $5,000. That cost me $5,000 to schedule a second deposition. Just to schedule. This wasn't to do it. This was to schedule it. And that was nothing on you guys. It just felt like the other side was playing hardball. They were only providing Sundays for a deposition, and then we had to go to court to resolve the matter.
Yeah, that's
frustrating.
That's why judges often get frustrated with parties who have to bring discovery disputes into court. Because realistically, most of the time, these are things that the parties should be able to figure out themselves.
Right.
And it wastes, attorneys' fees for everyone involved. It wastes the court's time.
She was frustrated. You could tell from the start. I remember that. She seemed to voice her opinion at them. Okay, so we kind of discovered, but what's next for my case? We're waiting on, essentially, the judge will either choose to award the anti-SLAPP, which would essentially dismiss the case, or decide that it needs to go to court. Is that accurate?
Well, there are really a few different ways this could come out, actually. The court could either find that the anti-SLAPP motion, that these statements don't qualify for the anti-SLAPP statute's protections, but also finds that Buczkowski's claims don't have any merit, in which case he would just grant this as a motion for summary judgment, in which case the claims would still be dismissed, but you wouldn't automatically be entitled to your attorney's fees. Another possibility is that the judge finds that some of the claims don't have any merit and just dismisses those, but finds that other claims do have merit and allows them to proceed to trial.
Got it. So theoretically, out of the 4, 1 could get dismissed, and then we have to fight for 3. And then appeal is an option. Are we allowed to discuss that?
Yeah. So if the anti-SLAPP statute allows for an immediate appeal if the anti-SLAPP motion is denied. So that means that if the anti-SLAPP motion gets denied, then we have the ability to go straight to the Ninth Circuit.
Ninth Circuit, is that a state?
No, that is the federal Ninth Circuit Court of Appeals. So it covers, California, Nevada, a whole bunch of other Western states.
And then do you feel like the chance to have the anti-SLAPP granted is more probable in an appellate court or in the federal court?
I think that in general, a federal court is going to have a better understanding of the legal issues, and they're going to have more time and pay more attention to the legal issues. So an appellate court is a good safeguard against a judge who doesn't have the best grasp of the law, or just has an especially busy schedule. I'm not going to make any kind of predictions as to whether the Ninth Circuit is more likely to come to the correct decision than the judge we have assigned.
Okay, got it. But we at least have two opportunities. If we have to go to an appellate court and they were to determine that the anti-SLAPP motion should be granted, I still would receive attorney's fees if the anti-SLAPP motion is granted. So we essentially have two checkpoints. And at either one, if they determine that the anti-SLAPP motion should be granted, I would receive attorney's fees.
Yes. Though, keep in mind, as I mentioned before, that Buczkowski, if he loses here at the district court, he also has the option of appealing.
Okay, gotcha. And you would have to go to court essentially to provide defense for me, even though he's appealing.
Yes.
So we would still have to file briefs?
Yes. They'd be discussing more or less the same issues as what we've already filed. But, an appellate brief is generally a more involved process than filing a motion in a district court.
I did find out about supersedious bonds, though. That's a legal term, I know. Mm-hmm. I could pass a legal test, maybe. That's essentially it. Have you enjoyed litigating against Derek Moneyberg? This
has been a really interesting anti-SLAPP case. It's involved some interesting legal issues, a lot of legal issues that we've dealt with before, but the facts have been fun. For better or worse, Buczkowski's been a fun plaintiff.
I was served on June 2021. This is May 12th. It's been almost 2 years, 2 full years, and we still haven't reached the decision yet by the judge. So this has been an incredibly challenging time. This has been the biggest challenge of my life, for sure. I mean, not only financially, mentally, it's been what's made it really tough is the fact that I'm a creator and that you need creative space. Like I need mental energy. I've been burnt out for a year and a half. Like I haven't had the ability to take 2 days off. Like I've had to work and work and work to pay legal fees, and it's always a black cloud above your head because I don't know what's next. And this whole time I didn't know what's next because this is my first time going through this. And so it's been very damaging. Like I believe just the way of the world, the energy is going to come back to me. I just feel like this has been an incredibly unfair situation on me. And the fact that I've stomached all the expenses, I'm very proud of myself for being able to work as hard as I have and been able to make as much as I've had to then pay off the fees to this point. But it's been a real challenge. In my YouTube channel, I haven't been able to invest in my channel the way I'd hoped because every dollar set aside is for potential legal fees. So it's been a challenge. I think it's negatively impacted my career, probably very, very much so.
Yeah, I don't think that anyone has said that they enjoy getting sued.
Yeah, it's brutal, man. This is my first time. The whole time I didn't know what to expect. Like I truly thought that it would be like 30 to 50 grand and that it would take maybe 6 months max. Like that was like, whoa, 6 months max.
Yeah.
You just immediately file something and the judge determines it to be over. That's what I thought.
If we were in state court, that would be a much more likely outcome. Yeah.
Yeah. And so this, 2 years has been weighing on me, and it's been really about the past year and a half has been the tough, because the first 6 months there wasn't much. And so it wasn't too damaging. There really isn't that much work in the initial stages, but then as it starts to pick up, it became really challenging. And it's been hard. It's been hard as a creative to invest back in my content and try to stay in a good mood. Like I've just been. Hopefully, I haven't shown it to you guys, but I mean, the last 6 months has been hell. So we're gonna win. We're gonna win. We will not lose. I will not back down to him, and we will do whatever it takes to win because we cannot let him win. This is for all of YouTube. Also, I stand for all of YouTube. We cannot let a bully use the legal system to silence criticism.
Yeah, I mean, the point of an anti-SLAPP statute, and especially Nevada's, is to show SLAPP plaintiffs that their tactics don't work, that it's counterproductive.
That's it. If anyone needs any legal help, Randazzo Legal Group here in Nevada, would you be able to help anyone if, let's say, they lived in Colorado, even though you weren't licensed there?
We practice, we take a bunch of cases in states where we don't necessarily have licensed attorneys. We know a bunch of attorneys licensed in a bunch of different states, and we can help out on those cases.
I can't wait for our next podcast because me, you, and Mark in September, middle of September, when we are granted the anti-SLAPP motion and the case is over, whenever that day comes, we're going to case closed.
I look forward to it.
Yeah, we're going to make a great podcast discussing how we won. I can't wait. Thanks for joining me.
Yeah, thank you.